Hi, I'm Garrett Green of the law firm of Nichols Green. I've been practicing law in Fairfax County since 1989. I'm a lifelong resident of the county since 1964, and I've done hundreds of marijuana possession cases over the course of my career. Today, I want to go over the first offender 18.2 251 program for marijuana possession. The 251 program is a diversionary program that, after requiring you to plead guilty, does not find you guilty, but has you participate in a program with certain terms and conditions, which, if you fulfill all of them, will result in a dismissal of the case. The 251 program is available for people who have no prior drug-related convictions and are willing to forfeit their right to drive for 6 months, do 24 hours of community service, and test negative for a half year at the probation office, as well as going through a 10-week program. The cost of the program is approximately $350. Once you get through those first 6 months, you're on inactive probation for an additional 6 months, during which time you have to be of general good behavior, commit no crimes, and at the conclusion of all that, your case will be dismissed. When you do the program, at the conclusion of the case, assuming you're successful, it will show that the case was dismissed. However, because it requires you on the front end to plead guilty, even though they don't find you guilty, you can never get that charge expunged from your record. It's forever. The 251 program, you only get one in a lifetime. Once you've used it up, you can never have another, and you've been tagged. If you were not the operator of the motor vehicle and were simply a passenger, if you're willing to do a total of 74 hours community service, in other words 50 more than the 24 statutorily required for everybody, and that's within the discretion of the judge, you can avoid that loss of license. Some judges might prefer to grant you a restricted driving privilege as another possibility, but it is very much within the discretion of the judge. Often you can get a restricted license with the 251 program, but it is within the discretion of the judge who you happen to be in front of that day. Participating in the 251 program is a problem for people who are not full U.S. citizens because it requires agreeing to plead guilty to a crime. Even if the case gets dismissed, for immigration purposes, it's problematic. You should likely consult an immigration lawyer who knows your particulars, your status, and how it might impact you. But in general, it's something to be avoided by people who are not full U.S. citizens. Participating in the 251 program can also be a problem for people who intend to serve our country. It's not necessarily an absolute bar, but it's something you'll have to answer to. Ideally, you want a case dismissed if you can. The 251 program can cause you grief when you are attempting to join the armed forces. If you are not able to successfully complete the terms and conditions of the 251 program, it's really the worst of all possible outcomes. You end up with a conviction. Now, on a first offense, the maximum jail term allowable is 30 days, and it's rare to see anyone jailed for a first offense. But the 6 months loss of license will come down. And at that point, you've both suffered the conviction and the provision for a loss of license without getting any of the benefits. So if you're going to participate in the program, you need to be confident that you're going to be able to complete all terms and conditions. If you don't want to participate in the 251 program for any number of reasons, being either that unable or unwilling to give up drug use, or lack of time to do the community service, or an unwillingness to have to put up with the license suspension that comes with it, this is where you need the assistance of legal representation to interface with the prosecution and attempt to get alternative outcomes. These outcomes can be amending the charge to one of drug paraphernalia, which, while a Class 1 misdemeanor, would involve typically no jail time to serve, no loss of license, no community service, and no negative test results, just a fine in the neighborhood of a couple $100. If you've agreed to the 251 program and now want to get out of it, once again, this is going to be something that requires legal assistance. We would recommend that the case date be advanced and that you be convicted and then note the appeal. And then in circuit court, we can try again, likely with a different prosecutor and certainly with a different judge on the bench. I hope you found this brief video presentation helpful to your questions and concerns regarding the Marijuana First Offense Program, the 18.2251. Everyone's case is different, everyone's concerns are different. We invite you here at the firm of Nichols Green to call us for a free consultation, either in person or on the telephone at your preference, so we can go over the facts of your case and determine how we can help you. Thank you.